on this episode of Indiana Education Insight.
Nowhere in the Indiana Code is there any reference to 30 days.
That defined timeline.
Yeah, nor has there been really any reference to it in any case law prior. This is really a new thing that the public access counselor opined upon.
Every week, the Indiana Association of Public School Superintendents is taking you inside today's Indiana education collaboration and tomorrow's education trends. We're staying on the pulse of public school innovators throughout Indiana and beyond. Join our conversation and contribute to our upcoming topics at iapssin.org/podcast. Here's your host, Dr. J.T. Koopman.
Thanks for joining us on today's episode of Indiana Education Insight. I'm Dr. J.T. Koopman, Executive Director of the IPSS. This podcast is being delivered by our IPSS team and produced by our friends at Edge Media Studios. As Executive Director of IPSS, I'm excited to bring you this weekly show where we feature Indiana education innovators from all over our great state, from students to superintendents. We'll also be talking to higher education leaders and educators at the state level as we work together as proactive public education advocates. That's why IPSS is here and why we're proud to bring you this show. Every week we're talking about trending topics in the public education space while bringing in Indiana education innovators to hear from their perspective. As with any organization, it takes great leaderships to be successful, and that is one of the main missions of IPSS, developing great school district leaders. It is always great to have experienced and passionate educators joining us on the show, so let's get started with today's conversation.
Topics and trends in Indiana education.
Today's guests are Amy Mathews and Andrew Manna, school attorneys and experts in all things school law. They have made several presentations as well as numerous public speaking engagements, so they have been instrumental in shaping the conversation about Indiana public schools and have the ability to look at education from various lenses, which is why it's important and why they have been tremendous assets for public education. Let's find out how they view issues at Indiana public schools. Welcome, Mrs. Mathews and Mr. Manna. We're thrilled to have you join us on today's podcast. So if you would, please tell us a little bit about your backgrounds and your various roles in Indiana school law.
Yes, thank you, Dr. Koopman. We're happy to be here today. The topic we're discussing today is in the realm of school human resources law, and that's right in line with my background, as I worked for several years with the Indiana State Personnel Department, working with all types of employee groups, including educators, on all kinds of human resources matters. Then I went to work with the Indiana Education Employment Relations Board, which your viewers may well know by the rather clunky acronym of ERB, and worked exclusively on educational matters there.
Sure.
And was blessed to be able to come and work as a full-time school attorney with the wonderful team at Church, Hiddle, and Antrim. And we work with all sorts of areas of school law, as you're aware, including human resources and bargaining and policy development and student litigation matters. I could go on, but I think I would take all of the time that your viewers have today. So I'll stop there and just say that we're pleased to be here today.
Well, good, thank you. Andrew, how about you?
Thank you, Dr. Koopman, for having us this morning. I was trained as a middle school social studies teacher. I still have my wife as a teacher as well. And so with that teaching background in mind, I started to explore what's my next step, thinking about administration, the path maybe that you took, or getting into some sort of area of law. I really was fortunate to stumble upon school law and enjoy this process of working with administrators, navigating both state and federal law. So about the past 10 years at Church, Hiddle, and Antrim, similar background with Amy on working on student policy, litigation, employee matters. So we have some of those topics we'll hit on today.
Okay, well, good. So can you explain some of the recent employment-related public access counselors' decisions?
Well, our Indiana law really requires disclosure to requesters of what's called the factual basis for a final action resulting in suspension, dismissal, or demotion. And decisions over the past year have really honed in on the PAC's opinion, the Public Access Counselor. That role, position in state government, has issued a series of opinions on what constitutes a factual basis and what constitutes one of these three covered disciplinary actions of demotion, dismissal, or suspension. And the factual basis opinions, one of them deals with whether a factual basis disclosure by a school or really any government entity must be more detailed than a statement of the policy provision that was violated. Andrew, would you like to share about that particular decision?
Sure. I'll start with a little bit of the framework that Amy just described. When we're looking at, under Indiana law, that we have this process for adjudicating a fact that's involved with a suspension, demotion, or discharge. Normally, to kick things off, we have a crisis or a situation, investigation that may need to happen. And from there, we have an employee that would be put on paid leave. And from paid leave, we may end up with a resignation. We may end up with a media, public relations statement. We may end up with an actual termination, cancellation process. So there's a variety of those different avenues that happen when one of these situations take place. And in the last year, there's been a number of decisions, opinions coming from the Public Access Counselor talking about this topic. And we also have the background and framework of some recent court cases that discuss what you can say when an employee is being suspended, demoted, or discharged. So with all of that framework in mind, about a year ago, there was a Public Access Counselor opinion, and that was, I'll just cite the Access Counselor number, 17-FC181. This was a decision saying when you put somebody on paid leave, that's not a substantive decision. That's not a final action as contemplated under the Access to Public Records Act. Once a decision is final by your board or administration, either one, that's when it becomes a suspension, demotion, or termination. And that's when, as Amy cited a moment ago, the statute comes into effect that you would have to discuss with the public what the factual basis is. When that final decision happens, not just when paid leave happens. So we've always operated under that premise. We've guided clients, superintendents, when dealing with personnel matters, that paid leave is an option to be able to look into a situation. Most recently, though, we have had a newer decision in this spring of 2017-18 school year, where there was a practice of using an ID number for an employee, or at least there was a first attempt or a decision made to use an ID. And from there was a request under the Public Records Act for the name and the reasons why that employee was being suspended. After a Public Access Counselor opinion was requested, the decision said you have to give a factual basis that contemplates at least one fact. So you have to talk about, was there a violation of board policy, for example, or poor instruction? And understandable. But we also know, going back, for example, to 2003, there was a Indiana newspaper versus Indiana University. I believe this was the Coach Knight case that said you don't have to give specifics and intimate details. So the fact that we understand that we have to at least mention something, a fact about the factual basis, that came from this decision 17-FC09. And we understand that, but it's now a balancing act when somebody goes on paid leave to try to give enough information to the public, but also respect the rights of the employee.
Yeah, both rights of privacy and potential for litigation in that regard as well.
So does this kind of muddy the waters when, as school administrators, we talk about personnel issues and that protects the person that is being addressed in some way by the school corporation? Does that muddy the waters as far as the, quote, personnel issue is concerned?
It may, and time will tell how case law develops. This is, as we said, these are opinions that we're talking about from a state agency. So they may or may not become official law in court cases. But that is a consideration to make, that the public access decisions, that those opinions are reading this way in favor of more information being shared, and always balancing that desire for more information with the protection of employee privacy and potential for litigation on that side. So as Andrew said, a balancing act to be achieved, yes.
So, not being an attorney, can a public access counselor's opinion, when something goes to court, be entered in as some form of an argument, or does it have to be case law used as argument?
It certainly can be entered. It's a matter of how much weight it is given, and there are other things to be considered as well. As we said, there are going to be court decisions along with that, and over time, there are different public access counselor opinions on some of the same matters. In fact, one of the cases we have to discuss today, there were 2 cases in a pretty short period of time dealing with the same area. Andrew, would you like to talk about that?
Sure. And I'll dovetail, piggyback on that comment. There are all sorts of agencies and law firms and opinions that take place regarding interpretation of Indiana law, interpretation of federal law. Our opinion is one of those opinions. The public access counselor is one of those opinions. And so we try to strike a balance here of understanding what is the statute and what is the meaning. With respect to some of the decisions that Amy started to mention a moment ago, that prior a year ago decision of July 2017 simply said you do not have to give out a factual basis under the Access to Public Records Act if you're putting somebody on paid leave. We've had this question come up last Friday, for example. We did a presentation with our Indiana School Board Association friends, where someone approached afterwards, an administrator said, well, what do I do here when the employee is on leave, is considering a resignation? Do I then go out and give their personnel file information? Well, their personnel file information is discretionary on the part of the school district when we're having a request for Public Records Act. And so to talk about the factual basis when there hasn't been an adjudication of the facts, that's where we do get into some litigation. We've had court cases that have gone on 3 and 4 years with a dispute about what a school district may have said with respect to that factual basis.
And was that actually a fact or not? And so schools have used their discretion to not disclose personnel file information, because that is, and not just schools, but really every public agency, it's pretty standard. As I said at the top of the show, I have a background having worked for state government. Yep. State agencies have and use that same discretion as well. So this isn't really a school issue. It's an issue for all public employers in the state. But that administrative leave piece that Andrew touched on, there had been cases saying administrative leave is not a final action typically, because it's something that is most often used in the course of an investigation to see if final action will be taken or not.
Right.
And many times, final action does not end up being taken.
Yep.
There are oftentimes complaints filed that end up having no merit to them. Right. Nothing is found, and the employee returns to work just as they were before. And so there, in those cases, we would argue in also the public access counselor decisions or opinions have said that is not a final action. But then recently, there has been a new decision that has implied that administrative leave can be basis for or a requirement, give rise to a requirement that a factual basis be given. Andrew, can you talk about that piece, please?
So that decision was, I'll give the example, some administrators who may have been put on administrative leave so an investigation could take place. And then again, as we referenced a few minutes ago, that investigation is meant to pull together information. It may sometimes be a police investigation. It may be an accusation against a staff member, against a teacher, against an administrator. So as the board and as the school corporation and as administration start to look into examples, paid leave is used as a mechanism to allow that investigation to take place.
Right.
Well, on the very first day of that administrative leave for the investigation to take place, a records request was made to understand and ask for the factual basis of the disciplinary action. The school's position and the administration's position at that point is there is no disciplinary action. We're simply looking into what's going on here. And as we've been pointing out, we have to be careful with considerations of defamation and not fully have agreement on whatever the allegation may be. So in this particular public access counselor opinion, this was 18 FC 34, February of 2018, recent this year. Some administrators resigned during the process of this leave, and there was no discipline, in fact, happening. Unfortunately, as part of their policies, though, the particular school corporation had a policy that used paid leave as an example of disciplinary action. So there's a question of, really, should you have that in your laundry list of disciplinary consequences, that paid leave is a disciplinary consequence? Some schools have decided recently to remove that and maybe touch that up and not have that in the array of options. But the ultimate decision here in this particular case that we were talking about is that the public access counselor said it could be that over 30 days that really is a disciplinary act. Leaving someone on leave longer than 30 days would be considered a disciplinary act. I should probably clarify that's not in the Indiana Code.
Yeah, we would be remiss if we didn't tell your viewers that nowhere in the Indiana Code is there any reference to 30 days.
A defined timeline.
Yeah, nor has there been really any reference to it in any case law prior. This is really a new thing that the public access counselor opined upon.
So where does this leave school administrators? I mean, we're kind of in no man's land, so to speak, from what I'm hearing.
Well, every situation is going to be a little bit different. So there are some steps, as Andrew mentioned, the particular case that just came up with administrative leave, that was a situation where the policy muddied the waters in terms of whether administrative leave was a discipline or was an investigatory technique.
Right.
So that's one piece of tips for your superintendent viewers. Another is to look at, is your investigation prompt and thorough and continuous? There may have been some facts to be added in that case that weren't necessarily added in terms of progress of the investigation to demonstrate that the investigation was ongoing and that no final action had been taken. But, of course, no one in that case thought to do that because this 30-day piece had never been out there before.
Sure.
So there was some sense that school was taken unawares by that, as they would have been,
right,
because this was brand new. So I think eyes open and paying attention as superintendents always are in general, but just to add this to the list and the balancing act.
You know, as school administrators, especially more experienced school administrators, they have a process that they follow. And now it seems like to me that in even some, what I would consider to be some very simple proceedings, you may need to consult with your counsel on and not just do business as usual.
Yes, that may well be, and especially with some of your administrators who, as you said, have not done this as long, are not as experienced, and also administrative teams have grown smaller over the years as budget and funding changes have been made. So this isn't necessarily a bad thing. Of course, we as attorneys are going to say it's not a bad thing. We want to help folks. But even from the perspective of the administrators themselves, it's not necessarily a bad thing because they don't have as many folks to have as a sounding board anyway.
Right.
Or to stop and consult with and start to work through even a simple process and to make sure that they're on solid ground and they're comfortable with, and that their board is comfortable with, and that their community will be comfortable with the steps that they're taking.
Sure.
That sounding board role and that help through the process is really a valued part of our relationship with administrators. And I think something that they appreciate having the opportunity to do, not only in, but especially in those administrative teams that aren't as large.
Right. Andrew?
I'll go back to the 30-day question just for a moment. The question being, if you put somebody out on paid leave while you're doing an investigation into something that may be controversial, and very important to the employee, very important to the administration, to the school district, to the teachers, to the parents, to the community, if we have an allegation of wrongdoing, 30 days or more may be necessary. And we encourage cooperation, positive relationship with local law enforcement, often facilitating something being looked into with local law enforcement. We can help generate a timeline that meets everybody's expectations.
Sure.
But that 30-day marker really is not in statute. So
And 30 days is not a long time. We know this. And especially when you're talking about external agencies being involved as well, that school administrators want to be respectful to them as well,
Yep.
that 30 days may not be enough to handle those complexities.
So I was just going to conclude that comment or that thought of exactly as Amy said, 30 days or more. Sometimes we've seen up to 6 months, a year, to properly look into an investigation. So I would encourage administration, consult with your local attorney, talk it through. It may be important. It may be necessary.
Sure. Now, so what does this mean in respect to, let's say, a first-year teacher not performing well, and the school administrator does not want to renew that contract? Are there any consequences or things we can talk about here with that? Seems like a pretty simple, straightforward procedure, but maybe not.
So under the teacher non-renewal process for a first-year, even second-year teacher, we have a statutory language that says we can have a cancellation for probationary teachers for any reason relevant to the school corporation's interest. So any reason relevant to the school corporation's interest, you would think would be a pretty open territory for removing a teacher.
Right.
But we still have a statutory contract in place. We have a school board process to be the final finder of fact. And so on a first-year teacher, we would still have to do paid leave. We would still have to allow a resignation or accept a resignation, I should say, if somebody resigns. It may not happen that we fall under the statutory scheme of giving a final action or factual basis because we've had a first-year teacher that we've decided was not a good fit. That does take me to one other recent decision that was a public access counselor opinion. This one dealt with talking about whether a request for a reassignment was actually voluntary. So just like a resignation, we would hope would be voluntary. If somebody has decided, for example, they're not a good fit at a certain position, whether that be at administration or at a teaching assignment, and they've had a voluntary reassignment, we've allowed that to happen. We've worked with administration to facilitate that.
And that can be a positive outcome for everyone typically. And the statute, we don't believe was designed. There's no reason to believe that the statute was designed to discourage that positive outcome.
Yeah.
So February of 2018, this is 18 FC 24. These are the public access counselor citations.
For us law junkies out there and your viewers who are law junkies and like the numbers.
This basically said, simply make sure as administration working with someone doing a reassignment that you are going to have it truly be voluntary. And so you can give options, you can help people understand the landscape of what's being looked into with an investigation. But this may simply be the best fit for someone to do a reassignment or to do a resignation. And I think our emphasis point on this particular matter, this particular case was just make sure it's voluntary.
Sure. How about coaching positions?
Coaching positions can be a little bit different because it's not the same type of a contract at issue.
Yep.
For a teacher or an administrator, those are indefinite contracts, meaning they continue automatically unless they are canceled under the statute.
Right.
But a coaching contract is different. They generally can be allowed to expire on their own terms. So if they expire on their own terms, and the public access counselor's recent comments have supported this interpretation, if they expire on their own terms, there's no demotion or dismissal under the statute, and therefore not a factual basis.
Right.
However, many times it may be a matter of timing of when the contract terminates. Andrew, can you talk a little bit about that?
Sure. With a coach, we sometimes see that the contract term is from July 1st or August 1st through the end of the school year term, through June 30th, for example.
Yeah, the typical school contract period that your viewers are used to.
And as Amy pointed out, if that contract term is set, a starting point and an end point, and we've decided after reviewing a coach's performance, or maybe there was an incident during the season, that term is going to be allowed to expire, there's no suspension, there's no demotion, there's no discharge. That contract is simply allowed to expire. But as we brainstormed a little bit internally at our office, we thought maybe we don't always want to encourage our school clients, our administration, to make that a school year term. Maybe you want to make that term the period of the coaching season. So when that season ends, their contract or their coaching position ends.
And thus you don't have the whole question of, is there a need for a factual basis? Is there the privacy concern?
Sure.
A lot of that can be alleviated in those cases.
Well, it seems like to me as a school administrator, if you allow it to just run its course and expire on its own, with the understanding between the employee and the administration, if that's what's going to happen, that's a pretty easy course of action to take.
Yes.
Now, on the other hand, you've got parents who want to call for the coach's head and say, I demand action now. Well, that action could be, I suppose, taken immediately, or you could just tell the parent the contract is not going to renew it at the end of its term. So any advice for that?
Well, that is one of the many challenges that our school administrators face in terms of not just the legalities, but the practicalities and the community relationships at issue. And I think that goes back to some of the conversation we were having before about, do you consult with the school attorney and kind of balance the risk factors depending on the situation and what those allegations or concerns that the community is making are.
JT, I'm sure back in your history you did some coaching. I did as well, and I just noticed an article in the newspaper in the last couple of days that talked about how coaching has changed with the predominance of parent involvement and opinions on how to coach.
Sure.
But yeah, on coaching, I think that if we do decide we're going to cut off midstream the right of the coach for that contract, we may have a suspension, a demotion, or discharge if it's in the middle of their coaching contract. If we, though, allow it to just expire on its terms at the end of that period of time, no. I think the overall takeaway is just striking a balance. We understand that there's community curiosity sometimes as to what's going on with a coach, but in terms of just letting it expire on its terms, that wouldn't fit under the statutory scheme of a suspension, demotion, or discharge.
Okay. All right. So talking about all of these things, does that mean that we should not use paid leave any longer?
Well, the need for paid leave for an investigation for that determining whether misconduct actually occurred is going to continue to be a need. Mm-hmm. And especially in today's litigious society and unfortunately the many allegations that are made throughout the state in the course of a year, that's going to continue to be a need. But the question becomes those paid leaves that are not investigatory in nature.
Sure.
And also making sure that it's absolutely clear which type of a leave we're talking about here. And that goes back to that policy aspect of things that we discussed earlier, that we don't have policies or procedures that make it less clear as to whether we're conducting an investigation or we're issuing final action.
Okay. Andrew?
I think that the other overarching piece here with either school employee, teacher, coach, anything that we're talking about, when we're talking about striking that balance of getting the community the information about what's going on with a school employee, we also have to consider is the Family Education Rights Privacy Act and the fact that sometimes students are involved. So any time that we have a student involved with a situation, maybe there's a student-related incident, we also have to consider the overlap of FERPA and what goes on with protecting student information. So one of the reasons Amy and I felt it was important to talk to your audience this morning is to remember both what the statutory scheme for employees says, but also understand we have some student privacy considerations as well.
Yeah. And the concerns of your community, as you mentioned earlier.
Right. So knowing, again, that this has kind of muddied the waters, so to speak, how does this impact policy review? Andrew, you had mentioned that earlier, I believe.
We've undertaken in the past couple of years the need to just go back and work with administration, work with schools on touching up, deciding whether everything that you've had in there for years is still relevant today. And one of those that we found was paid leave listed under the disciplinary consequences may be something we want to go back and take another look at.
Yes, and that concept that the world has changed a lot. There have been a lot of changes in the law.
Sure.
And just to also look at not only what is legal, but what, as a practical matter and as a practice, school administrations are actually doing and what they're actually using within policy or not using.
Yeah.
That there may be some items that create an expectation or a thought that procedures are being done a certain way, when in actuality and practice, that may not be the case. So it's important also to make sure that paper and practice match up.
Okay, good point. Good point. So what are some other legal issues that schools are facing these days?
I'll go with one consideration that touches on the topics we've been discussing today would be, I think, in the next horizon of information sharing and what you are required under the Access to Public Records Act in Indiana. We've seen decisions in the past with respect to school board, administration, teacher use of private email, and the fact that private email, if you're using it for a public purpose, may have to be disclosed. I think we need to make listeners aware as well. A lot of the interaction and the communication that they're doing, whether it be a personnel matter or daily functions, more and more we're seeing use of text messaging.
Right.
So as a highlight, maybe you should pay attention, there have been some public access counselor opinions and court decisions out there about texting and whether, even if it's on your own device, whether you should pay attention to texting as a use or possible public record.
That's interesting. That almost seems like an invasion of privacy if it's on their own personal device and not on a school-owned device. I mean, that was pretty clear the way it was before on school-owned devices. That becomes a matter of public record. On personal devices, you can't access it. So now, again, we're in another muddied water
blurred
aspect.
lines.
Yeah, interesting.
Yes, I mean, exactly. There are some criminal area cases that say you don't necessarily have to allow access to your phone. Your phone is like your brain, and you're self-incriminating yourself in the criminal law world. So I don't know where this is headed, but I know that we've seen some hey, pay attention opinions that would say if you're using it for public purposes, you have a responsibility. You have retention laws as well. And so we're not quite there yet in terms of our office and our overall opinion from Church, Hill, and Antrim.
And I don't think the world is there yet in terms of the external guidance really available to tell us where to go with that.
I just think this is the, hey, be aware that that's the possibility.
Right. Yeah. Well, there's been many. I don't know if they're court cases or not. You would know this, that Google or Apple or other folks have not been compelled to release that information, even in some pretty significant criminal cases. Is that still the case or not? I don't know.
Well, this is such a quickly changing area of the law, and such an area that impacts private employers, public employers, and then individuals, just private citizens and public servants, so to speak. So it is that constant battle, and that balancing act we've been talking about for the entire show here has been continues and kind of the tug of war between privacy and transparency when it comes to government. And those are the two concepts here that are really at war, the transparency and the privacy. And so how it will shake out under Indiana law is still an open question.
One thing I think is a asterisk caveat to that as well. We've talked a lot today about the Access to Public Records Act. I think the listeners should keep in mind as well, if we get into litigation, lawsuit, courtroom, the power of a state or federal court judge to order you to disclose your text messaging or email when it comes to a personnel decision or any decision involving public schools. But we've got access to public records as one domain. We've got litigation as another domain. So, always keeping in mind what we're saying in our exchange of information.
Yeah, I interesting times. I tell the new superintendents, I said, don't put anything on electronic media that you would not want your grandmother to read on the front page of the paper.
Yep, very good advice, Dr. Koopman.
So we don't want superintendents getting themselves into difficulty by simply using electronic transmissions in an inappropriate way. So that's my word of advice for them. So I guess I should extend that to text messaging now too, right?
New frontier, yes.
New frontier. So what should we tell school administrators in relationship to when and if to involve counsel and their school attorney?
Well, as you know today's school administrators are pulled in so many different directions. And they've got pressure from their families, from their employees, from their communities, and a lot of that pressure is to respond immediately.
Right.
And with the advent of texting and those other real-time communication methods, that immediacy is everywhere. And so we would encourage the administrators to step back a second and really take a breath and evaluate and try to help prevent a molehill from becoming a mountain. And that is one of the areas, along with that sounding board and really the problem solving and the ability to help with troubleshooting are all services and skills that an attorney can help them with.
We continue to help and explore as counsel for schools. I think Amy hit on it just a second ago, but it's the fact that you have this real-time information, social media, that can get out there in front of things before you've had a chance to analyze them. So the sooner the better. We're always there to pick up things on the weekend or off hours to help administration through difficult times.
Well, when in doubt, make sure you consult with your counsel. That'll always keep you at least in line to some degree. Don't go out there on your own. Well, I certainly want to thank Mrs. Mathews and Mr. Manna for being our guest on the IEPSS edition of the Indiana Education Insight.
Well, thank you for having us. It's been a pleasure.
Great conversation.
Thank you, sir.
And I know that our audience will benefit just from the conversations that we've had today. So thank you so much for being here. And I also want to thank you for what you do for Indiana schools and school leaders. You and your law firm are simply well respected, and when you react when you're called. So thank you for that. We appreciate it.
Thank you. It's our great honor.
Now it's time to wrap up this edition with my take on the current state of affairs in the Indiana education landscape. There are many factors that go into preparing all students to become lifelong learners and contributors in the 21st century. As such, we need to begin to change the dialogue. We are approaching another General Assembly session in 2019 with the knowledge we need a different approach on how schools are recruiting and retaining teachers, and an important aspect of that is teacher salaries, as well as respect of the profession. In light of that fact, educators are the very fabric upon which this country was built and the primary pillar of our democracy. Should this not be part of our public dialogue? I see these as investments in our children and in our state, not as an expenditure. Perhaps we can pursue this issue and others in another segment. On our next show, June 18th, we welcome Mrs. Carol Griffith, Vice President of the Teachers Credit Union. Perhaps she can provide some additional insight into the State House and education. Join us for that and more on the next Insight into Indiana Education. Thanks for being part of education. Please stand up for Indiana Public Schools.